Good morning, everyone. Welcome to the Appeals Court. I am Justice Rubin, and to my right, Justice Ditkoff, to my left, Justice Grant. We are hearing one case this morning. It is number 23-555, Stone and another versus the Town of Northborough Board of Appeals. And we will hear first from Attorney Lanza. Yes, please.
Again, good morning, Your Honors. I do appreciate the fact that the court accommodated my illness. I'm not completely over it. My voice isn't what it usually is, but I'll try my best to speak loud and project.
You can pull the microphone closer to yourself if you'd like, and that might help.
If it so pleases the court, my name is Mark Lanza. I represent the plaintiffs' appellants. As the court knows, they are challenging a decision of the Town of Northborough Zoning Board of Appeals granting a use variance for a project directly across the street from them, which will consist of a 20,000, give or take, square foot building, mainly warehouse use with some office use. As the court knows, the procedural history of the case is that the developer, Cable Matters, Inc., moved for summary judgment on both the standing issue and on the merits. A judge at the Superior Court, after holding a hearing, ruled on summary judgment that the plaintiffs' appellants did not have standing and didn't address the issue of the merits, presumably because lack of standing means lack of jurisdiction and no jurisdiction to deal with the merits. However, the judge didn't specifically rule that. The case languished for a while because no judgment was entered on the summary judgment decision. Then ultimately, I believe it was both the town and the developer moved for entry of a judgment of dismissal based on the judge's decision. In this case, there's no dispute that the plaintiffs' appellants have presumed standing. They are located directly across the street from the project. The distance between, it's a narrow street, the distance between the proposed building and their house is about 80 feet. So very close proximity. There's no structures or fences or trees or anything like that intervening in that space. It's pretty wide open. As the plaintiffs' appellants see it, this case presents a very narrow issue. Zoning cases, as I'm sure the court knows, can involve multiple complex issues, but this one, as we see it, is very narrow. And it's whether or not the Superior Court judge should have disposed of the standing issue on summary judgment.
So what do we do with the judge's finding that the defendants rebutted the presumption of standing because the plaintiffs had not shown any cognizable harm?
Well, the court, again, this is a review of a summary judgment decision, so there's no deference to the lower court. This court could independently find that the presumption was rebutted. However, this court on two occasions, this court and the SJC on two occasions, the Marhefka case and the 81 Spooner Road case, ruled that when that finding is made on summary judgment, then the case is not suitable for disposition on summary judgment because it presents a material fact that can only be determined after evidentiary hearing and trial. So in our view, there's really only two outcomes here: that the presumption was not rebutted, which we claim it was not rebutted. Of course, the judge agrees, the developer disagrees, the developer disagrees, in which case my clients have standing, and the case proceeds on the merits. Alternatively, if the Superior Court judge and the developer are both correct that the presumption was rebutted, then summary judgment should be denied, and the case should proceed, to a hearing or a trial on the merits on the summary judgment issue. If my clients succeed there, then it proceeds to the merits. But
what facts do you say are in dispute?
The impacts of the project on my client's property. He has Mr. Stone submitted a detailed multi-page affidavit explaining the harms that the project would have on his property, mainly noise during and after construction, unnatural light, odors, and fumes from the motor vehicles. Again, the loading docks are right across the street from his front door. So
So the judge says about noise, the summary judgment record is devoid of evidence regarding the existence, nature, or quantity of construction noise surrounding the building of a warehouse and office space on the premises, nor is there any evidence that any noise from such construction would harm the plaintiffs and that such harm would uniquely affect the plaintiffs as opposed to all other businesses and homes in the surrounding community. So where is the evidence that the judge missed? Where would I look for that?
that was specific to construction noise, and she explains in her footnote that construction noise might well not be a basis for standing, but noise usually is, and then she cites to the footnote, it's on page 3 of her decision, footnote 16 or 14, and goes on to say that noise unrelated to construction, and then lists, cites from the bylaw, all the other types of...
Okay, and then with respect to noise during operation, and this sort of is the gist of a lot of what the judge says, the answer is this house is right next to the industrial zone. There's already an enormous amount of truck traffic, noise, vibration. She says concussion from the delivery trucks. Okay, and that adding what is unrebutted, she says at least, one tractor trailer every 2 or 3 months, 3 UPS or Postal Service vans per day, all during weekday business hours, and the judge concludes that, assuming those facts are true, that is the facts, maybe you have facts that the judge missed, that there are more trucks or something, but she finds, let's assume that's true, so let's say there's no dispute about that, because it's unrebutted. That's just a de minimis increase.
Yeah, but there is a dispute about that. There's no, and we've heard this, during the ZBA hearings, during the summary judgment hearing, that there's almost implying that there's some sort of limit on the truck traffic.
No, I agree there may be no limit, obviously. There may be, I assume there's no limit once you've got it up and running, but that's not really the question, right? There's lots of things there's no limit to, but you don't have standing to object because there's nothing going on that actually affects your interest.
Well, my client says in his affidavit that, the noise from all these trucks, coming and going, backing up with backup beepers, the fumes from the diesel fuel, the unnatural light after sunset, the concussion, when these trucks are being unloaded and the loads are placed in the warehouse.
The problem with this affidavit is it says, backup beepers will sound and will be audible from our home. The exhaust fumes from these large vehicles will be detectable at our property. But I don't think you can challenge and establish standing just by saying that whatever's going to be next to you won't be silent and you can't smell anything. I mean, if you could do that, there would be no standing requirement at all. And where in this affidavit do we find anything that rises to the level of actionable aggrievement?
Well, he describes the impacts.
Well, I just read what he
and again,
wrote.
this is the
what
project.
Did he say beyond that? What do you say beyond that?
And again, this is, he says they're going to adversely affect me and my property, and here's what they are. He specifies them, okay? On summary judgment, the motion judge is supposed to accept that as true and not go any further, and that's just what she did. She didn't accept it as true.
If we accept it's true, backup beepers will sound and will be audible from our home. That's enough to give you standing?
Sure. I mean, what if you go to bed at 8 o'clock and there's a truck delivery at 7:55 or 8:15, let's just say, and the backup beepers wake you up?
But I don't think the judge ignored that. She just said, this place is chock-a-block with trucks backing up, going forward, spewing, exhaust, idling, chock-a-block with it. There's no indication that it's going to be anything more than a few vans every business day, and a truck or two, I think, maybe a month. And that's a de minimis increase. What's your answer to that? It seems like she is accepting what your client says in the affidavit, but then saying, and that's just, because of what it's already like there, that's not really much of an infringement.
Yeah, but there is, again, there's no limit on the amount of traffic. So it's really not appropriate.
Well, but that's
to
true.
determine
All
the
right,
de minimis.
so I build a house across from another house, and the person with the pre-existing house says, you can't build that there. You could have 50 cars coming and going every day. And the other side says, no, we have 2 cars. Well, you could have 50. You could have parties every day and night, 50 cars. And they say, well, we've never done that before at our other house. We have no intention. I mean, are you able to just say there's no limit to what you can do so you have standing?
I think
I mean, I have to say, as someone who was reversed by the SJC when I found standing in the Sherburne case, I'm sympathetic to the injuries done to people's property by development, but it can't be that you can just say there is no limit and that gives me standing.
Yeah, well, that's really a factual issue of the amount of impact, whether it's substantial or insubstantial, and that's just not an issue that can be resolved on summary judgment.
Counselor,
and that's my client's position.
Before you run out of time,
let's have a hearing. Let's get into the details.
Before you run out of time, at no place in either of your briefs do you discuss whether any of these standing concerns are within the zone of interest of the DCOP bylaws, which are the only bylaws that are at issue here. I would like to hear your addressing those, because it seems like all those bylaws are about is water protection. I didn't see any water related harms.
Yeah, we don't claim that they were within the scope of concern of the specific groundwater protection provisions. They're separate from the rest. However, they are within the scope of concern of the bylaws, and the judge so found that they
But
are
since it
within.
complies with all those bylaws,
Yeah,
all those other bylaws, why does it matter that you have concerns within the scope of the bylaws that are complied with?
I'm not sure I understand you.
Okay, so we have a bunch of bylaws, not the DCOP bylaws, and I understand this warehouse satisfies every single one of those bylaws. There's no problem there. So why does it matter that you have concerns that are within the bylaws that are being done without the variance when you're challenging a variance?
Because the bylaw says if these impacts are present, then it could be grounds for standing or grounds for denial of the project. The bylaw prohibits those impacts from occurring as a result of the project, regardless of what district it's in.
But there's no variance from any of those requirements.
No,
There's only a variance from the DCOP.
That's correct. No variance from the general prohibitions of the bylaw. And I doubt the zoning board would consider a variance from those sort of provisions.
All right.
Unless the court has any other questions, I will give my voice a rest and rest
All
on
right,
our
I think we
briefs.
understand your argument. Thank you very much. Excellent argument.
Thank you for hearing me.
We will hear next from, I'm going to say, Attorney Brewer, though I could be wrong.
Good morning, Justice Rubin, Justice Ditkoff, Justice Grant. My name is Donna Brewer, and I represent Cable Matters, Inc., the developer in this matter. Mr. Lanza left out an important critical element of standing. Once the presumption of standing has been rebutted, then it is the obligation of the plaintiffs to provide credible evidence that they can show that they have an alleged harm to a protected property interest that is particularized to them. The plaintiffs have not done so in this case, as I believe has already been elucidated by your questions. If you look at the appellant's brief, they refer in the appendix only to that one affidavit those two paragraphs, paragraphs 5 and 6 of the affidavit, which are simply conclusions. They are simply statements of the impact, but they in fact do not provide any credible evidence of any of that impact.
Am I correct that the judge didn't address light from the parking lot lights?
She did not address the parking lot lights. However, in the appendix and in the deposition testimony of Mr. Stone, he said he didn't understand the lighting plan, he couldn't tell you what it said, and he doesn't have any idea of where these lights are going to be. Again, credible evidence
I guess
of
I don't.
adverse.
I guess I don't get that. Backup beepers will sound, will be audible from our home. That's got to be true. It can't be wrong,
Yes,
right?
There will be backup lights.
Exhaust fumes from these large vehicles will be detectable at our property. That can't possibly be false. And
Yes.
according to the project plans, the area of the loading docks, the parking area, and all entrances and exits will be lit with unnatural light, which will be visible from our home after sunset.
That's a conclusion that he makes. He provides no evidence of that. If you look at what the brief says,
That is evidence of that. That's a sworn affidavit.
The plans don't
Warren
say that?
it's a sworn affidavit of what he believes will be the result. But he does not provide any evidence that in fact supports that conclusion. It's purely speculative.
Are the parking areas going to be lit?
The parking areas will be lit up to 8 p.m.
How will he
And
not
ATMs
see
after
that light from his house to cross the street?
He will see the light, but we're back to he needs credible evidence that is more than de minimis. Simply having a light that you can see is an impact, but we know from the Picard case that an impact is not sufficient.
Is there a plan that shows where the lights will be?
There is in the record.
Including things like wattage or lumens, or I don't know how you measure lights, but something where someone who knew what they were doing could look at it and say, oh, that's going to be visible 200 meters away, or, whatever.
True, again, impact, visibility is not sufficient to show standard.
No, but I'm
To
asking if
standing.
it's in your record, if you've presented something that shows all of this so that someone could, again, I don't know if a homeowner has to do this, hire an expert who could look at it and say, oh, with that, I don't know if they need to, and I don't know if, you know what I mean, I'm not sure about this. But is there enough in the record that an expert could look at it and conclude how much light will come in their windows?
It's in the record, but I'm not certain if it's in the appendix. But yes, there was a presentation to the Zoning Board of Appeals on a whole lighting plan. Again, the brief actually, the appellate brief, the issue on lighting that is presented to you here, doesn't address the issue of the warehouse light or the parking light. They talk about the headlights. And the headlights, again, if we look at the case law says, the Marashlian case, that headlights are not sufficient for finding standing.
If you tell the person across the street, we're going to have one truck a month, and that's false, but you tell them that, and you tell the zoning board that, and I assume the variance isn't limited to one truck a month, how are they supposed to get credible evidence that, no, it's going to be one truck a day? Or where would they, how would they figure that out? They don't know what the volume of your business is going to be, and I assume you want the volume of your business to go up, right? So.
True. And in fact, both Mr. Chang in his testimony and in the traffic report state that if the business goes up, instead of having one tractor trailer every 3 months, maybe it will go to one every 2 months, maybe even 1 month. But again, we're back to how all of this affects his property interests in a material, non-de minimis way. The testimony was replete from the plaintiffs that they, in fact, are already suffering from noise, vibration, concussion, and so bad that they cannot sleep. It simply cannot be the case that adding lights, headlights that might be seen up to 8 p.m. are going to have any material impact on the suffering these people are already
Well, if they
having on
already
their
can't sleep, you can make any amount of noise, I guess.
Well, perhaps you could, but we're not. I mean, the unrebutted testimony, the unrebutted evidence is 2 USPS trucks up to 6 p.m.
Counsel, that kind of troubled me, and that's sort of the basis of the Superior Court's judgment, decision. And that would go to your special permit, which is not being appealed. But the variance is to construct a warehouse, and this warehouse can be sold to Amazon the day after it's constructed. And it's not like you could go and ask for it to be taken down at that point because there's different impacts. I mean, it seems, shouldn't the consideration be what does a warehouse in general cause, rather than the particular idiosyncratic use that your client intends to make of the warehouse, for the purposes of the variance, not for purposes of the special permit?
I don't think that would be appropriate, Your Honor. The board can only view the particular use that is applied before it.
Well, what if
And
I'm
it would be
a
improper.
developer and I say, I'm going to build a warehouse, but I'm not going to use it at all. Just going to build it, and I'm not going to use it, I'm not going to touch it, not going to turn on any lights, never going to come near it. Do they get a variance on the ground that no one could possibly be impacted by that? And then if the developer sells it after they build it, well, tough luck?
When a property is granted a variance, in particular a use variance, it is limited to the use that is presented to the board. If somebody is going to
But
turn this...
the use is warehouse use. You wouldn't have to
But
get a new variance to do a different kind of warehouse use, right?
It's a warehouse use with particular parameters, and those parameters were the basis of the application, and they're the basis of the decision.
So should the variance, I don't know what, I don't know what the variance looks like, I don't know how it's written. Should the variance therefore, or can the variance therefore include conditions like for use of a warehouse at which no more than one tractor trailer a month shall arrive, and at which no more than 2 USPS delivery trucks per day shall come always prior to 6 p.m.? And does that go in the variance? Can it go in?
It absolutely can.
But it didn't. But it didn't here. So why isn't that reversible? This variance doesn't have any of those requirements.
Nor does it need to. Again, we're
But you're
going
telling
back
me
to...
the variance is only good because of all these restrictions that don't exist in the variance.
You can't ask a board to be denying requests for relief from a zoning bylaw based on what may happen down the future. You have to, it would be improper, it would be incorrect for the Zoning Board of Appeals to deny this application.
Wait, but you just said they could include these conditions.
Correct.
So if your client decides to sell this to Amazon, Amazon won't buy it because they need 400 trucks a day, not one.
Correct.
And your client wouldn't mind that? Wouldn't mind if these conditions were written into the variance?
No, Your Honor.
So
no.
can we send it
I
back
mean,
for the variance to
again-
be modified to add all those things?
Again, the Zoning Board of Appeals did not believe any of that was necessary. The Zoning Board of Appeals granted a
Yes,
use
but
variance based
now we
upon-
have to figure out if it's necessary.
Well, no, we're not going to get there yet because we have the issue of standing and why we are here.
But the
And
judge defeats standing by pretending that all these requirements are part of the variance, but they're not.
No, the court looked at, again, we're back to the plaintiffs always have the burden of proving standing, of establishing their standing. Yes, they had a presumption here. It was rebutted by evidence from the planning board decision, from the testimony of Mr. Jang, and in fact by the testimony of the plaintiffs themselves. They need to show that they had more than a de minimis harm caused by this application, by this use.
Well, as long as it doesn't, I mean, I hadn't thought about this really until hearing Justice Ditkoff's question, but it seems to me that if you were going to have 400 trucks a day, that would not be de minimis. Even though there's already all this other stuff going on, that would be, it seems to me, burdensome on a house across the street, even though it's already noisy and so on.
The plaintiffs are not basing their argument for standing on the fact that there may be 400 trucks a day if this is sold to Amazon. They are basing it on the traffic report and the unrebutted testimony of Mr. Jang as to what the actual effect of this development will be on them. And in fact, it is speculative, it is conclusory, and it is de minimis. Indeed, if you look at their brief on page 9, when they are supposed to state what the credible evidence they have to support their conclusions, all they do is they say it is based on common sense. We know from the case law, specifically the Butler case, that common sense is not a sufficient basis to provide credible evidence of an impact that is adverse and more than de minimis. We know from the Standerwick case and 81 Spooner that Carew Vaselis applies, that so long as we can show that they do not have a reasonable expectation of proving that they have suffered an appreciable harm, that is more than de minimis, then we are in fact correct, and the trial court is correct in finding no standing. I can go through, if you want, the specific items and show you, but the testimony is replete that for all of these impacts that they are talking about, they are already suffering them from what already occurs in the industrial district. I do want to pick up on the point that Justice Ditkoff raised, which is one that I think bears repeating, and also, as Your Honor is well aware from the Murchison case, the plaintiff today has admitted that they are not relying on anything in the groundwater protection overlay district purposes and items to be protected. They're not relying on any of that for standing. And as the Murchison case tells us, when the particular zoning bylaw that is the focus of the action of the board and the focus of the use variance is not the basis of the harm being suffered or alleged to be suffered by the plaintiffs, then there in fact is no standing. I have nothing further, Your Honors.
Thank you.
I see no further questions. Thank you very much for an excellent argument. Each of you, the case is submitted.